This short video will give you a summary of the state of the law regarding online intermediaries and direct copyright infringement. So this applies where it is the intermediaries themselves who are doing the primary acts of copyright infringement rather than the users. And so this is different from copyright authorization claims. This matters for us as users because we are increasingly relying on intermediaries to help us manage our digital lives. For example, we may wish to store all our digital music or movie files that we have bought in the cloud using services such as Dropbox. This requires the intermediary that is operating the cloud service to make a copy of our files. Now, this copy is a reproduction under the Copyright Act and might be copyright infringement. There are exceptions in the Copyright Act which say that we as users may make copies of works that we have legitimately bought for certain purposes, such as storage. But the law is unclear about whether these exceptions extend to the intermediaries that might be exercising those acts on our behalf. It might seem intuitive that if we are relying on intermediaries to perform these functions for us so we can rely on the copyright exception, that they would also be covered. But the law is not in fact clear on this point. The authority in Australia is this case, DeGaris and Neville Jeffress Pidler, a 1990 case. Now this involved a news clipping service, so this was pre-internet. The defendant operated a news clipping service, and what they did was that when people had something to research, they could contact the news clipping service, give them the topic that they were researching, and then that service would then look through all the newspapers, make clippings of any articles relating to that topic, make copies of those clippings, and provide them to the person who needed that research. Now, because they were making copies of these newspapers, they were sued for copyright infringement, and the defendant argued that this was not infringement because they were relying on Section 40 of the Copyright Act, which provides an exception for copying a work for the purpose of research or study. So if you're copying a work for research or study and that copy is fair, it will not be an infringement. Now, in this case, the court held that the Section 40 exception for research or study only applies when you are doing your own research. So a person doing research for themselves will be covered by the exception, but an intermediary, like the defendant in this case, who is doing research for somebody else, will not be covered. So a person cannot rely on somebody else to exercise the exception for them. They have to be doing their own copies for their own research. And this case is still the authority in Australia on this point, and we'll look at a moment at how it's been applied in the digital age. But firstly, this position or this question came up in Canada in very similar circumstances, and I want to talk about this case, CCH Canadian and the Law Society of Upper Canada, a 2004 case, just to demonstrate how very differently the courts in Canada dealt with this question to how the Australian courts dealt with this question. So this case involved the library of the Law Society of Upper Canada. That's a picture of the outside of the library. And what the library was doing was making photocopies of books and articles on behalf of some of their patrons. The library was based in Toronto. Not everybody who wanted to use the library was in Toronto. Some of them lived a while away. And so they were contacting the library and asking library staff to make copies of certain works for them and send them the copies. So this is a very similar situation to what happened in Dagaris, and a similar question came before the court about whether this was copyright infringement. And the Supreme Court of Canada held almost exactly opposite to what the Australian courts held. So looking at the similar exception, fair dealing for research or study, Chief Justice McLaughlin said that the fair dealing exception is a user's right. In order to maintain the proper balance between the rights of the copyright owner and the rights of the user, it must not be interpreted restrictively. He also said that research must be given a large and liberal interpretation in order to ensure that users' rights are not unduly constrained, and that research is not limited to non-commercial or private research. So they took a much broader view of research than what the Australian court did. And in the context of the library of the Law Society of Canada, they said that the library staff making copies was simply part of the process of the user's research. The user could not access that research without the library making copies for them. So the Canadian Supreme Court said the relevant purpose here is that of the user. This is about the user needing research, not the library making the copies. You have to view it collectively or holistically as part of the process. And so what the library is doing is of course part of that research, and it is of course covered by the exception in the Copyright Act, and there was no infringement here. Now this case is important because it has been applied in the online context in Canada. So following the CCH case, there were a series of cases, sometimes called a pentology, copyright pentology, because there were 5 cases that applied the CCH reasoning in various different situations. And I want to focus on one case in particular that is relevant to our online context, and that is the Society of Composers, Authors and Music Publishers of Canada, SOCAN, and Bell Canada. SOCAN is a copyright collecting society in Canada, and Bell Canada is a Canadian ISP. Now this is a 2012 case. And the question for the court in this case was whether internet sites could provide previews of music files to customers who were thinking about buying them. So what they were doing was streaming 30 to 90-second clips of music to consumers to help the consumer decide whether to purchase the full song, the full music download. And the court said that this was not an infringement, this streaming of the music, because it was research if they applied the broad interpretation of research as set down by the Supreme Court in the CCH case. They said that users were doing research here because they were searching and investigating music files in order to decide whether they suited the user's taste. And they said again that the exception had to be looked at from the user's perspective, not the intermediary's perspective. So it didn't matter that the intermediary here was providing a commercial service. The relevant perspective was that of the user, and this streaming of music files to decide whether or not to purchase them in full constituted research under the exception in the Copyright Act. Now it's interesting to compare this again to the Australian courts, because we had another case in Australia in 2012, so in the same year that the SOCAN and Bell Canada case was decided. The National Rugby League and Singtel Optus case, which went to the full federal court. Now what happened in this case was that the NRL and the AFL own copyright in the TV broadcasts of their football games. And they granted an exclusive license to Telstra to screen those broadcasts on Telstra's internet and mobile phone services. What Optus did was develop a service which they called their TV Now service. and they allowed users to record the free-to-air broadcast of the TV broadcast of the football and play that back on their devices, including their computers, their mobile phones, and their tablets. NRL and Telstra were not happy, of course, because Telstra had spent a lot of money to get the exclusive contract for the footy, and Optus TV Now service allowed people to record and watch, sometimes only after a very short delay as to what the football was screened live to air on TV. So it could be a matter of minutes later that they were recording and playing back, almost live. Optus argued that all it was doing was allowing users to time shift the football broadcasts. There is an exception in the Copyright Act, section 111, which says that users can record something. So normally a TV program, in the old days you would record a tape on your VCR, in order to watch that program at a more convenient time. This is called time shifting. You shift the time at when you view the program. If it airs at a time that's inconvenient for you, perhaps because you're at work or doing something else, the Copyright Act says you're allowed to make a copy and watch it later. And Optus said that is all the TV Now service is doing, and we are just facilitating that service. We're just providing the technology to allow users to exercise their time shifting right. And the full federal court said no. What they did was they drew a very technical distinction between who is actually making the copy here. And they said it's not the same as users pressing a record button on their VCR at home. Here they put through a request to Optus to record the footy, and Optus is the one that starts the recording, that starts the copy. So it's Optus pressing the button, not the user. And then they applied the black letter of the law to say, Degaris tells us that the exception can only be exercised by the user, not by the intermediary on behalf of the user. So they drew a technical distinction, who's pressing the button, and then they applied the law strictly to say it has to be the user pressing the button, or else this is a copyright infringement. Now, the court here may have been influenced in part by the fact that Optus was somewhat of a bad actor here. They were cutting in on this very lucrative exclusive contract between Telstra and the NRL with a service that allowed people to view the football almost live in a way that undercut Telstra's contract rights. So that may have been an influence. But what this does is that it gives us a precedent that applies to Degaris in the digital age to say that intermediaries providing a service that facilitates users exercising an exception under the Copyright Act may not be allowed. And this is very important because it applies a very narrow approach to the law that may restrict what Australian users can do online in relation to relying on intermediaries to do certain services for them, in a way that users in Canada are not so restricted, because there the courts look at the holistic situation and how the intermediary is helping the user, and they look at the user's perspective and what the user is getting out of it. So in this way, we are much more constrained in Australia in relation to how copyright exceptions are applied online with intermediaries.